there was a hole in the roof.
Okay.
So the HOA responds as they should, and they said, hey, we're going to get this roofing company out. Okay. And there was a massive storm coming. One of those huge, what are they called? Atmospheric rivers.
Oh, yeah.
It was pushing down to Orange County. And it was going to happen in like the next day. So the roofers come out, they open up a big hole to sort of start fixing it, and they fail to cover the hole. They just leave it wide open, right? Sure enough, next day, huge storm comes in. I mean, I think like 20 units got absolutely destroyed by the rain.
Yeah.
Right? And, the association tried to sidestep it and say, hey, this was the roofer, not our fault. But I mean, that was a failure to repair compounded by, sort of a contractor failure.
Yeah.
But at the end of the day, it was the association who hired the contractor.
Right.
And through agency theory, it blows back to the board ultimately. So they can't hide behind the fact that, hey, it was a negligent, contractor.
Yeah.
But that was a, failure to repair that was compounded by a failure to repair properly. Right. So it was like a double whammy for these homeowners.
I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs.
Hi, Luke Carlson. Welcome back to Bad HOA today. And as always, I have Marty. Marty, welcome.
Good morning, good afternoon, good evening, and good night, or whatever they say on
That's
the
close
Truman
enough.
Show. Yeah.
Well, welcome back.
Thanks.
I wanted to start off really on a high note, and we were talking about this before the show. We brought back our Reddit. What is his name?
Snoo. Yeah.
Because Reddit is on fire right now.
When we started the idea of Reddit, it was recognizing the space, and
Yeah.
there was a lot of subreddits out there, and they were all with like expletives associated with them,
Yes.
which just means that people want to go out there and complain and have a community to complain to, and there's a great time and place for it. Reddit is actually a wonderful place if you want to throw a complaint out there and have the community rally around you and lift you up. Great place to do it.
Well, as we discussed, that was sort of evolution 1 of Reddit.
Yeah.
And it brought together these individuals, these homeowners that were in crisis.
Yeah.
And it gave them a platform to say, hey, I'm not alone in this situation.
Which is huge.
I think that in and of itself was a tremendous benefit to the homeowners who were dealing with really bad HOAs.
Agreed.
And then you and I discussed it, though. It's like, how do we level that up? What's the next evolution of it?
Yes.
And that's where Bad HOA comes into play. It was a subreddit based on Bad HOA, based upon the community. And really the driving force behind it was, okay, how can we be solution focused?
Yeah. Instead of just complaints and putting it out there to the community, it was like, well, how can we put out the content? Because you've been in this space for so long, there's a wealth of knowledge. And if we can have a central hub for community to talk to each other and bring people together that have had similar situations, and just start to be the driving force on, I guess that homeowner empowerment piece would be huge.
Well, yeah, it was, but what I think was really cool for both of us to see is that was the theory behind it.
Yeah.
How can we create a solution focused platform on Reddit and to see that thing explode? To see the engagement, the community that's really developed.
Yeah.
And what I love about it too is, we come up with strategies that we've seen historically, tactics, and what the community does very well. And what I absolutely love and applaud is where they say, hey, I tried this, but I tried a little bit of a different angle on it.
That I think is the ultimate power, the superpower of that subreddit is that the community comes in and says, we try to be the seeder, if you will, the ones that are like the facilitator of it and try to put good content that, when you have a dispute, it's nice to go to a place and feel seen like, oh, I see my dispute in the eyes of these people. And we hope that we can put in content where people see their own dispute in there and feel empowered. And the community comes in and say, this, we tried this, but we made a modification here. And that homeowner now feels, oh, I can try this. And it worked.
Different approaches, right?
Oh,
There's so many different approaches. And I'm just very, I couldn't be more enthusiastic.
Well, it goes back to what you said before. If you can solve an HOA dispute without a lawyer, it's a huge
win.
It's a huge win. I mean, economically, there's so many reasons why it's a great thing. And to be able to take this knowledge transfer and just put it out there and develop like these tools, like you have in front of you, like the homeowner empowerment kit.
I'll bring this up again because, this thing, see if it goes into focus. It should.
Pull back. Oh, there it is. There it is.
The homeowner empowerment kit, I mean, when we put it up, it was just flying off the shelf, digital shelf, right? Because it's digital.
We had a lot of downloads of that, and it just shows that people are hungry for content that is focused on solving these solutions.
Again, solution focused. And so when you start to give them a framework, when you start to give them the tools, now they're empowered. Whereas before they're kind of scrapping it together, and it was just a very cool thing to see really come to life. And the momentum that we've built in 26 is outstanding. I mean, it's blown me away. It's blown away our estimates.
Oh, I mean, you hope that some of these initiatives really take off, but the biggest win is when you hear people over and over again that have either walked through a consult, hey, we've watched your podcast, or I read the book and solved the problem, and now they've been to Reddit and solved the problem. I think that's tremendous. By the way, to go back an episode or two ago with all of our empowered homeowner merch.
Yes.
We had a big run of we did a first order of that and did a big run of it. And that was gone within, I think, less than 2 days. It was all gone.
There was a mad rush, and that was exciting to see. I think you actually have the only this is the only mug in our stock right now.
And the only reason I didn't give this away is because I used it.
I guess that is showing that, we're doing something that's meaningful. But I think we're also going to put in another big order, and we'll do another one and just keep the merch flowing.
Yeah, and just get people the billboards, if you will, like the signal that you shouldn't be messed with.
Yeah,
which I find great.
I love it. All right back to now, I suppose, topic of the day.
Yes. Okay. So we are back in our series revisiting this is the dispute series revisited. For those of you that don't know, we are taking a look. Going back to Reddit for a second, there's so much of what we've done over the past several years and dozens of episodes previously that you realize that, hey, a lot of these can be solved within systems.
Right.
And we came up with the strike method that I felt like was a really easy way for people to like see their disputes and, hey, here's your 1, 2, 3, 4, 5 step guide. And so after you kind of go and look at it in that lens, some of our original podcasts, these were our first ones, right? Even though it had really good information, it's like we now have a new framework. We have a new lens to
another evolution.
It's an evolution. Yeah. This is the 2026 version of these. So I thought it would be, we thought collectively it would be helpful to go through these. So this is our third installment of the dispute types revisited, and today we are going to revisit failure to repair,
which is so massive. I mean, this one comes up time and time again, and it's funny. I was renting a car recently, and someone asked me, he says, what do I do? I said, I'm a lawyer. He's like, what type of lawyer? I was like, well, I actually am, I represent homeowners against really bad HOAs.
Yeah.
He goes into a massive failure to repair story.
How funny.
Which, sort of to my point, I mean, they're so common, unfortunately. I mean, if you want to talk about something that has massive disruption to life, talk about failure to repair.
Well, I remember when we flew to Sacramento, for instance, right? For the AB 130. And we were on the plane and people asked the same thing. And every time that you mention, lawyer and what type of law, and you say HOA, everyone has a story.
Yes.
It without fail, someone's going to bring it up and say, "Oh, my brother, my wife, or whoever had this issue with an HOA." It's a lightning rod. Everyone's got a story,
right? And hopefully we're chipping away at that, right?
Yeah.
We're trying to get better HOAs out there, maybe one HOA at a time. So,
yeah.
All right, let's jump into it.
Okay. What does the HOA actually owe you? I think it's a good place to start, right? Because at the end of the day, the preview here is your HOA has a legal duty to maintain and repair common areas. And then when they don't, homeowners typically have real leverage here.
Yeah. So when we talk about failure to repair, what you're really talking about is an obligation by way of the board to make repairs.
Yeah.
So how does that come about? Well, first, obviously, there has to be notification or notice.
Yeah.
Right. So if something is in a state of disrepair, let's say a roof,
Yeah.
and you know about it, or the homeowners know about it,
Yeah.
obviously you have to communicate that to the board. But you have to realize too, the board also has an obligation to maintain, inspect, and to use reasonable care when it comes to these common area sectors of the community, right? So it's not simply, well, we never heard about it, therefore we have no obligation.
Yeah.
Right. It is an affirmative obligation. I mean, if you have a roof, you have to not only maintain the roof, you have to repair the roof, but you also have to make sure that it's in good working condition, which means you have to go out and inspect.
Yeah.
Right. And so the failure to repair is where there's been a absolute failure from the board to do just that. And it's caused some sort of damage, right?
Sure.
There's sort of that second piece, right? So we're talking about a hole in the roof. It results in water intrusion into your unit.
Yep.
Okay, now you have damage as a result of a failure.
Right. Well, let's go through some of those categories.
Yeah.
So one would be the common areas. Easy to define. Pools, clubhouses, roofs in condos, hallways, elevators.
Well, this one you hear about quite a bit. I mean, this is your typical, hey, we're paying all this money for a community pool and the pool is in a complete state of disrepair. Now, then you say, well, how does that actually impact, the homeowner? Well, one, obviously it takes away an amenity, right?
Yeah.
But it also hurts fair market value.
Yeah. I mean, if you're trying to sell your house and we've all been on Zillow and you're looking at pictures of the last 5 pictures are always dedicated to the community.
Right.
The pool looks pretty crummy.
For better or worse.
For better or worse, the pool looks pretty crummy. It's not going to help your fair market value.
Yeah, if it looks like a swamp, right?
Yeah.
That's a big problem.
And if they don't have a picture, then it's even worse.
Correct. You may want to inspect.
Right. It's always like the other ones at Zillow when they don't show the exterior of the house as the first picture. They show the interior. I'm like, oh.
Red flag.
Red flag.
Yeah. Very true, though. But, again, common areas. And then there's also a health and safety element as well. We talk about hallways, maintaining those, making sure that those are in good conditions.
Elevators,
all of this ingress, egress, gates, back exit. I mean, these, again, they have these affirmative obligations to maintain and ensure that they're in a working condition.
Yeah.
And so not only does it necessarily maybe drive down fair market value, which it typically does on some level, but you're also looking at the health and safety of the community.
Yeah. Yeah, so. Absolutely. The other ones on there were landscaping, drainage, and exterior walls. So again, that could be keeping people out too, right?
Exactly.
And security gates and things along those lines. Okay. Number 2, exclusive use common areas. What are those? Patios. Do you want me to define it?
No, go ahead.
Patios, balconies, parking spaces assigned to a unit, but technically are common area.
Yeah. So this gets interesting. And often this is it should be very well articulated in the CC&Rs.
Yeah.
So you have a homeowner, they have a beautiful patio. And by the way, there's a whole bunch of legislation that came out on patios and maintaining patios.
Yes.
Right?
We have an episode on the law updates for 2026 that actually go through some of those.
Yeah.
That was on there.
And that was critical because, if a patio fails, I mean, it's a huge problem.
Yeah.
And we're talking life and death.
Yeah, for sure.
And so to understand it though, it's not that the homeowner owns the patio.
Right.
Right. It's a common area element, but they have the exclusive use right.
Yeah.
Only they can use it, meaning other people can't just start using your patio. Right. I mean,
could you imagine someone gets a ladder and like, I'm using the common area patio.
Right. I'm sure it's happened before.
I'm sure.
But yeah, again, it's sort of that common area. The maintenance obligation is under the defined by the CC&Rs, typically defined by the CC&Rs, or it defaults to Davis-Stirling. But ultimately, the obligations to maintain and repair fall on the board.
Yeah, makes sense. Okay. Separate interests. Your unit, just to define it, right? The interior of your home, typically your responsibility, right? This makes more sense in I guess the guise of a condo.
We're talking about condos here.
Right? Like this becomes failure to repair in a condo is very
condos, townhomes.
Yes.
So you are responsible for the walls, everything sort of inside that unit.
Yeah.
But a good example, and typically where you run into a failure to maintain issue, is for example, the pipes between the walls.
Right.
9 times out of 10, that's common area.
Yeah.
So if you have a community failing to maintain those pipes burst and create these huge, massive water intrusion events, that becomes very problematic, obviously for the homeowner whose unit just got flooded, but also for the board.
Yeah. And I think there's a whole nother thing about, there's a leak behind it. If that's behind the wall in a condo, the HOA's, likely the HOA's responsibility.
Well, the challenge there too is, the homeowner doesn't necessarily have a legal right to go in and repair.
Right.
And sometimes I've seen it where they've gone in and they've, because it was leaking and it was sort of an emergency situation, which is kind of an exception. And we can get into that. But, they'll make repairs and the association will lose their mind and say, hey, you didn't have the right to do that. And it becomes a legal battle over the maintenance and repair of a common area pipe, but it was done so in response to an emergency situation.
Well, that goes back to, remember the LA Times article that you were mentioning was all about the condo, that the person's unit making changes inside of that condo, but it was opening up walls and like changing a wall structure, which caused big time problems with the HOA.
A perfect example.
Yeah.
Yep. So that's what we're talking about though, when it's sort of that inside space.
So who maintains what, right? Well, that's defined in the CC&Rs. This is where the rubber meets the road, right? And we can talk. I'll read off the bullet points, and we can talk about it. The association is generally responsible for common areas. Exclusive use common areas can be tricky. The CC&Rs may split responsibilities. Homeowner maintains the surface. Association maintains the structural components.
Just briefly on that point, you look at very well articulated CC&Rs. They typically have some sort of matrix. Like they have a chart that kind of builds the whole thing out. Very helpful. And if you're about to buy a house or a condo, if you ask for the CC&Rs, that's a good sign that maybe these CC&Rs, some thought went behind them when someone actually took the trouble to actually carve out a matrix, as opposed to some of the more archaic ones that are it's just so complicated. You actually have to build out your own maintenance matrix.
Yeah, chiseled in stone.
Right.
They're on tablets.
Well, it's typically, you can tell is drafted on a typewriter.
Yeah.
Sometimes,
I've seen them.
Sometimes you actually see like a cutout that was put over and then it was scanned or not scanned. Sorry, photocopied. Yeah. To make corrections.
Yeah, it's pretty
archaic.
Yeah, or they take the white out and they try to go over it again.
Right. Yep. I've seen that.
Yeah. So anyway, yes, CC&Rs. It's pretty well defined, or should be in the CC&R. And then it goes back to again. Know your CC&Rs. That is the first place. Whenever there's a problem, the last episode was all about CC&R violations, and we talked a lot about it's not the restrictions or the handcuffs that the homeowner gets, strapped with.
Right.
It's also lays out the responsibility of what the HOA is responsible for.
Well, a good strategy too. We talk about really good CC&Rs when they're articulate. They don't have the ambiguity of some of the older ones.
Right.
But if a homeowner is going through CC&Rs, identifies some ambiguities, and really just can't answer the question because of how poorly they're drafted, the homeowner has the right to reach out to the board and ask for clarification.
Yes.
That's a really good strategy to say, dear board, I'm on section 2.73. I don't know how to read this. What's the official
I think that's a great idea.
So just one way to get clarification if it's not there.
Yeah.
Don't wait to run into a buzzsaw, in other words.
Let's talk a little bit about, so there's a little bit of a legal framework here, right? There's now, again, California, Davis-Stirling Act is the one that talks a lot about these, talks about maintenance of common areas, talks about wood destroying pests or organisms, talks about reserve study requirements, enforcement and governing documents, and then needless to say, several others. But there is a legal framework for a lot of this, just making the point of the Davis-Stirling Act does cover quite a bit in terms of maintenance.
Well, what's really positive and strong about the Davis-Stirling Act is it sort of contemplated a world where your CC&Rs are imperfect. Remember, these are quasi-governments. These are, sort of these little units that are supposed to run themselves. And in the wisdom of the drafters of Davis-Stirling, they said, well, what if they screw something up that's really important?
Mm.
What happens is it will default to the Davis-Stirling.
Yeah.
So if, the association governing documents are silent on something, the association can't be like, well, not our fault.
It's not in our documents.
Not in our documents, right? Because it would actually sort of encourage that poor drafting.
Right.
So what happens is it defaults to Davis-Stirling.
Makes a ton of sense. Yeah. But it also goes back to hierarchy too. It cannot be CC&Rs, rules, bylaws, whatever is listed there cannot be in conflict with Davis-Stirling.
Yeah. So in other words, it can't say, hey, we're not responsible for any of this stuff, even though the Davis-Stirling says you are, right? So
I mean that we laugh, but it does happen where particularly when laws change over time and after the CC&Rs were drafted and things like ADUs or drought tolerant landscape or solar come into effect, now those, basically render those CC&Rs, at least those provisions in the CC&Rs, void.
Yeah. So you have that. And then you also have, I would say, some of the smaller associations, which are more Wild West in a way where it's, a group of 4 individuals.
Yeah.
And you see some really wacky things coming out of those situations. Not to say that those are all bad, but when you really see overreach or you get one really tyrant type personality in charge of a very small community, you get some very bizarre CC&Rs. I've seen that over the last, 17 years plus.
Yeah.
So,
yeah, that's interesting. Okay, let's talk a little bit about fiduciary duty, like the connection there. So we talked a little bit about it last time, but let's just briefly touch on the board members have a fiduciary duty to protect the property values. Deferring maintenance to save money while sitting on the reserves is arguably a breach of fiduciary.
Yeah. So if you go back to sort of this concept, you look at the standard of care, and that gets you into sort of this world of negligence, right? What is the reasonable person's response to a situation that's in legal terms considered, standard of care?
Yeah.
Right. So when you bring in fiduciary, that is a heightened standard of care. That's an extraordinary sort of, if standard of care is here, fiduciary is a much higher threshold. So it's almost, extraordinary standard of care, right?
Yeah.
Because they're in charge of these massive communities, millions and millions and millions of dollars of real estate.
I know that's what blows me away is that people don't understand like what they have. Do some simple math. Let's say 100 homes, $1 million a piece. It's $100 million that in $100 million in real estate.
So you got that, right? So you got the real estate.
Yeah.
Compounded with the fact that we're really dealing with life, safety, all of these real elements that could impact not only property values, but someone's life.
Yeah.
Right. So, the law, rightfully so, says, these boards actually owe these homeowners a fiduciary duty. And when we start talking about, failure to maintain or, they forgot to inspect a roof or they forgot to, inspect the patios, right?
Yeah.
Not only is it a form of negligence because it falls below the standard of care, but you're also likely going to be arguing breach of fiduciary. So it sort of goes hand in hand in a lot of ways.
Yeah.
So it's that heightened standard of care that they owe you or that duty.
That's interesting. Let's go into some real world examples, shall we?
Yes.
Okay. Let's do the leaking roof. That's the easiest one, I think, for everyone to wrap their head around, right? Because it just makes the most sense, particularly in condo associations. Okay, so a condo association knows that the roof is failing. Multiple homeowners report water intrusion. Board defers the repair for years, citing budget constraints, while its reserves sit unused. Units suffer mold, drywall damage, personal property damage.
Yeah, leaking roof is very common. An interesting variation on this one that I saw years ago was there was a hole in the roof.
Okay.
So the HOA responds as they should, and they said, hey, we're going to get this roofing company out. Okay. And there was a massive storm coming. One of those huge, what are they called? Atmospheric rivers.
Oh, yeah.
Pushing down to Orange County. And it was going to happen in the next day. So the roofers come out, they open up a big hole to sort of start fixing it, and they fail to cover the hole. They just leave it wide open, right? Sure enough, next day, huge storm comes in. I mean, I think 20 units got absolutely destroyed by the rain.
Yeah.
Right? And, the association tried to sidestep it and say, hey, this was the roofer, not our fault. But I mean, that was a failure to repair compounded by, sort of a contractor failure.
Yeah.
But at the end of the day, it was the association who hired the contractor.
Right.
And through agency theory, it blows back to the board ultimately. So they can't hide behind the fact that, hey, it was a negligent, contractor.
Yeah.
But that was a, failure to repair that was compounded by a failure to repair properly. Right. So it was like a double whammy for these homeowners.
Yeah. And
So-
it's assuming at one point they go after the roofer for negligence, but it's still, it's the blowback back to the board.
Correct. And so, you have to look at how are they actually repairing to? Just the fact that they've gotten someone out there and they have a contractor, to kind of provide a more heightened relationship to it is saying, well, who is this contractor? Are they bonded? Are they licensed? Are they
Fair
doing
point,
a good
actually.
job? Are
Yeah.
they doing a shoddy job? Like, what are they actually doing to repair?
Yeah.
Right? And then again, that goes to fiduciary, that goes to negligence, that goes to the standard of care.
Honestly, didn't even think about that. To hire contractors with that fiduciary is a lot more like, you can't just find the guy on the side of the road or hey, my
Right.
brother can do that.
Yeah.
It's like, he'll do it for a bag of Cheetos
Right.
on a Sunday.
Right. So that's another part of this examination
Yeah.
that has to happen.
Yeah.
You get these situations where mold breaks out and they hire a painter to paint over the mold.
Yeah.
Right. Again, it's like, okay, is there negligence in their response?
Interesting.
repair.
Yeah. Yeah. All right. Second one, the neglected drain. Common area drainage system fails. Water pools near foundations. Board ignores requests. Eventually, a homeowner's foundation cracks or a retaining wall fails.
Yeah. Normally when you see these, this is some sort of drainage issue that's been going on for some time.
Yeah.
And it's just ongoing failures to maintain.
Well, and like at least here in Southern California, rain is few and far between in many cases. But sometimes, like in certain times of the year, we've got a week or two long of just of heavy rain, and all of a sudden all those issues. It's easy to ignore something that's like, oh, we're gonna get to that, and then when it doesn't rain 10 months out of the year, and then it does.
Right.
You know what I mean? It's not like in this Pacific Northwest and it rains every other day.
Right.
It's like, we could push that off a little bit.
Right. Well, it's interesting. When there's a big rain event in California, our phones light up pretty quickly.
Yeah.
Because of that issue.
Yeah.
This is deferred maintenance or oversight or both.
Yeah. Okay. Selective repair. Board repairs the clubhouse roof immediately, but ignores building 3's roof for 2 years.
Yeah. Interestingly, boards do have the right under the business judgment rule to make decisions.
Yeah.
But, where it gets very, how do I say it? Quickly starts violating fiduciary responsibilities, is inconsistent with Davis-Stirling, is where you have, the president's roof was repaired on day one and no one else has been repaired since. Right. You start to look at this preferential treatment.
Right. It's compounded.
All the board members, their, parking garages are in perfect working condition, but no one else's are. Right. Or, you start to see this sort of selective or preferential sort of treatment of what are we repairing?
Yeah.
I've seen historically the landscaping. Landscaping is beautiful in front of the board president's home. And every other part of the neighborhood looks absolutely horrific. So you have to be very mindful of that too.
Yeah.
Which is interesting because, on some level they did a great job here, but it was self-interested.
Yeah.
And that starts to become that breach of fiduciary.
Right. The It's Your Problem dodge. Association tells homeowner the leak is their responsibility when it's coming from a common area pipe or roof. Board mischaracterizes maintenance boundaries to avoid spending money.
Oh, that's so common. Common tactic. It's you reach out to the management company. Management company says, "Hey, you know what? That's on you."
Yeah.
And you say, "Well, it's a common area pipe. I can't fix it if I wanted to." Crickets. They just want to ignore the problem.
Yeah.
And so that's, typically where there's some other ways to escalate the dispute, which I think we're going to get into.
Yeah. Okay. The deferred maintenance death spiral. Board underfunds reserves year after year, then hits homeowners with a massive special assessment when everything breaks at once. That is brutal. And we see it so often on our subreddit.
Yeah, often that's, negligence in the financial sector.
Right.
That is a board who doesn't understand how to keep books or is just reckless. Often I've actually seen, or I have seen situations where it is 100%, stealing, self-dealing. Some contractors are getting paid a lot of money, and that's why they never have money. So the fact that a board is severely underfunded is a massive red flag.
Yeah.
And should be investigated because you find a lot of interesting scenarios at play as to why. It's not simply because, we used, best practices when it comes to our accounting. We have projections. We understand everything to a T in terms of what we're going to spend. It's often, if you really dive in, why is this contractor getting paid 10 times what everyone else is getting paid? Oh, you realize it's the board president's cousin.
The best ones are the ones I feel so often that transparency is like the window in, right? No pun intended, but like when a board is completely transparent, here's books, here's why we're doing it, and it's been ongoing for years. Like they're always super transparent. Here's your quarterly, financials. And then they explain why they're doing X, Y, and Z and how much it's going to cost. Like, I feel like those are the ones that run really well. It's the ones that hide or keep things concealed is the main red flag. The alarm bell should be going off with lack of transparency.
Well, it's very hard to embezzle when you're handing out, evidence that you're embezzling. It's easier to embezzle when you don't hand out that information or you doctor it.
Yeah.
One or both,
Yeah.
So transparency, I always say when people are buying a home before they buy a home, how much information can you get? How readily available is it?
Yeah.
And if you're able to dive into financials with like little to no friction, typically a good sign because they have nothing to hide.
Yeah.
It's always or typically is a massive red flag where you can't get the financials, you can't get the CC&Rs, you can't figure out what is the most current version of the CC&Rs. Their website is antiquated, nothing works, you can't download any information. There's no board meetings. I mean, these are all huge red flags that there's something really problematic with this quasi-government.
Yeah. Yeah. Okay. I love this one, and we don't talk about this quite enough on this, but the power of an independent expert report.
Oh, those are, it cannot be understated. Because at the end of the day, you can observe something as a layperson, and it's pretty obvious. Hey, the water's coming from this point, or this is the point of intrusion, or this is the point of failure. You can even get your lawyer to show up, and the lawyer will say, yeah, I concur. I agree with that. But at the end of the day, it doesn't really matter because I'm not a water intrusion expert.
Yeah.
The homeowner, assuming they're not a water intrusion expert, their opinion is sort of irrelevant to an extent.
Sure.
But when you get in an expert in water intrusion, that starts to carry weight.
Yeah.
And so often what I see is, homeowners attacking these problems sort of without that backing. They say, hey, this is the problem. This is what I've observed. Okay, at least you're starting somewhere, right? And maybe you have photos or video of it. And I think that's a great start. But to give it teeth, you say, hey, I hired this third party, and the third party says that I'm 100% right. And here's the report.
Yeah. To bring it back to one of the examples that we gave, the drainage of the community isn't working right. And every time it rains, it starts flowing. That water that should have been flowing down the drain is flowing into your property.
Right.
And thus cause an issue with we'll call it the foundation. Well, foundation, they could kick down the HOA, say, no, it's just your foundation. Your problem. You should handle it. But getting someone to talk about like a foundation expert, if you will,
right.
And or a drainage expert to come out and write a report that says this is what we believe the causation is of this structural issue.
Yeah.
That's where it becomes extremely beneficial and powerful.
Yeah, the pushback I see sometimes from homeowners is, they're not allowed to do destructive testing, which sometimes is right because if it's a common area, they can't.
Right.
They're too expensive.
Right.
But you have to understand too, you can bring on an expert on different levels. You don't have to go all into a destructive testing of the foundation. You can actually bring an expert in earlier, and just upon their observations, the information at hand, they can start drawing some preliminary opinions.
Yeah.
Contingent upon maybe more thorough investigations, but start somewhere.
That's a good point, because if they can just go in there and say, well, we have to do this and tear out walls, we believe the evidence suggests that it's pointing to here, and you hand them the report,
Right.
and then you say, look, I mean, that carries, I'm sure that carries more weight. That at least gets their attention.
Yeah. And listen, hopefully the board is good enough to actually hire their expert then.
Yes.
And now that expert is seeing a report from another third party. And now, okay, now we have something. Versus the expert is hearing an opinion from a lawyer. They don't care about your lawyer's opinion. Now they do on the law.
Yes.
Right. That's important. But if the lawyer is opining on, water intrusion or foundations or technical elements, right, that they don't have the background or experience, it doesn't really carry the weight.
Well, it's as silly as asking that the roofer about the who is responsible from a legal standpoint.
Correct. Yes, the inverse is also
the
true.
inverse is, it makes no sense.
So, the expert opinion, regardless of how thorough it is, or I guess not thorough, but how deep it goes, it's still worth its weight in gold, even if it's just some preliminary opinions on the topic or on the issue.
I think the gotchas should be, though, make sure they're a licensed professional in that very particular field.
Your expert does matter.
Yeah.
It can't just be some random person who doesn't have any experience.
Right.
Right. So you want them to be licensed. You want them to be credentialed.
Yes.
They don't have to be the creme de la creme, $5,000 an hour expert.
Right.
But they have to have the experience or the CV to back their opinion.
Right.
And normally with the issues that you see in an association context, they are somewhat easy to source.
Yeah. Well, the other thing that they can help do is quantify the damage amount too. That okay, this is, preliminary shows $47,000 or whatever the case is in damage, which also helps the thing along.
You can almost splinter this into, okay, you have the failure to repair a common area element, but then you start looking at the damage to the property.
Yeah.
So you can bring in an expert certainly to say, hey, the flooring is going to cost $50. The remodel of the kitchen is going to cost $70.
Yeah.
All of these things start to build up, as opposed to you independently saying, hey, I think it's going to cost $50.
Sure.
So now you're backing your damage expert with real quotes.
Yeah. Let's move. Let's keep going. The key concept: the notice and duty to act. Once an association has notice of a problem, written complaint, inspection report, board minutes acknowledging the issue, the clock starts ticking. Failure to act after notice strengthens a homeowner's case significantly.
Yeah, and I'm going to say this in the inverse too. If you notice a problem, right? Let's say there's a leak in your unit.
Yeah.
And you don't say anything for months and months. You are going to have a very tough time enforcing your rights.
Yeah.
Not to get too technical, but there's a concept called latches in the law. And what it says is you have an obligation to be proactive with your rights, or if your rights are being violated, you need to enforce.
Right.
Right. And so if you sit around and that little drip, if it was caught right away, would have cost maybe $1,000 in damage.
Yeah.
But you let it fester for 9 months. You're going to have, again, a lot of those damages are on you at some point.
Sure.
So that is an affirmative obligation to notify the association.
Yeah.
You just can't sit on these issues.
Well, it's not their fault that they were never notified.
Correct. Now, of course, they do have an obligation to inspect, but sometimes some of these things, the association, even under reasonable inspection, may not be able to observe what you're observing. I mean, take an exclusive use common area. There might be something very discreet that they just don't have access to.
Or, I mean, the leaky roof might be a decent one. Like, I see no signs of trouble here.
Yeah, under reasonable inspection, there was nothing that showed that there was a leak, or there was a hole, or there was a water intrusion situation. But you're seeing it from your side.
Yeah.
So again, that is an affirmative obligation. But yes, once they are notified, again, do it in writing.
Yeah.
Just don't tell the board president in the hallway of the problem. Send a formal email notifying them.
Which is a perfect segue to the strike method.
Yep. All right.
Okay. So strike method, for those of you who don't know, it's a framework. It's a starting point that if you want to try to solve this on your own, it is an acronym.
Yep.
Right. Strike. That kind of walks you through the steps on what you can do as a homeowner to try to resolve this on your own. So let's jump into it in the realm of failure to repair. Okay. So S, stay calm.
So important.
Yeah. Ceiling is leaking, mold is growing, and the board won't return your calls. Emotions run high. but the clinical approach usually wins.
Yeah, this is where you see, at least I've seen historically, the all caps email screaming, yelling at the board. Is it justified? 100%, because you have a water intrusion event. But if you can just stay calm and just think that whatever you say is going to possibly be used as evidence down the road, or it's going to be someone's interpretation of you.
Yes.
Is this person rational? And I mean, listen, if you're sending an email where water is pouring into your unit and it is calm, cool, collected, that's going to speak a lot to your character and who you are.
Yeah.
Even though you don't feel that way, that's fine.
Yeah.
But at the end of the day, if you say, hey, it's now this time, I've tried to contact you guys, I'm going to make some additional calls, I'm going to keep calling you because obviously this is a very pressing issue. I've notified you historically that that this was a problem. Now it's really come to a head.
Yeah.
I mean, that's versus, you guys are idiots, you guys are a dumpster fire. I mean, right? Which one reads better optically?
Yes.
So the S is very critical in these situations.
Yeah. Document, don't vent. A photo of a moldy wall with a timestamp is worth more than 10 angry emails.
100%. Yep.
Yeah.
Very well said.
Okay. Track everything. Date of first notice to the association, email, letter, verbal, but memorialize a verbal conversation in writing. Every follow-up communication, photos, videos of damage, progression over time, time-stamped, repair estimates from licensed contractors, any board meeting minutes where the issue was discussed, request these. And this goes back to memorializing an email also in writing. You can say something to the effect of, this confirms our conversation on date regarding the issue. If anything is inaccurate, please respond in writing. So, yeah.
Well, I think track everything too goes to, even if it's not necessarily put in front of the board, just to keep your thoughts organized.
I think that's a fair point.
Because it's very easy, especially when you're dealing with some sort of massive damage event to your unit, to get caught up in the emotion and things are going to be moving very quickly. You might have to relocate. You may have to put some of your furniture in storage, but just to kind of keep track of that. Hey, on Monday we had to move out. I had to put my stuff in storage on a Tuesday. Now you have this really clean timeline of what happened.
Yeah.
And even if initially you're taking it on your phone, your smartphone, you're just kind of keeping it in the notes.
Yeah.
That's a good starting point because sort of these situations kind of blur together as one just big horrible event versus, hey, this is what happened over the last 17 days.
For sure.
Very powerful.
I remember when my son 8 years ago when he was born, he was in the hospital for a long, long time when he was born. And I remember like taking notes of like each little thing so I could bring it to the doctor, and then looking back at him, like even months later, you don't remember 90% of those things.
No, there's too much going on. I think it's too stressful. Your brain isn't categorizing it. At 7:00 on Tuesday, I got a phone call from the board.
Right.
Or I didn't get a phone call. Right.
Yeah.
So to keep that log is going to be so beneficial, especially if things go really south.
Yeah.
So that's a great tip.
Okay. R, record and organize evidence. It's kind of tied in with T as well. Build a damage timeline, when it started, when you reported it, when the board did or didn't do, what the board did or didn't do, how damage progressed, get the independent repair estimates. Don't rely on the board's contractor. Photograph comparable areas that were repaired. Selective maintenance equals selective enforcement, right? Get those and then hire the independent expert.
Yeah, the T and the R, the way I see it is, when you're tracking everything, that might be a little bit of you're tracking things from all over the place, but you're kind of keeping it in one place. The R kind of goes into, okay, now I'm putting this all together.
Yeah.
Like I'm actually like organizing what has transpired.
This goes back to also a lot of this assumes that this might go all the way. And what I mean by that is this might end up in a courtroom one day. I mean, you're organizing this and you're starting from the ground zero, understanding that it could go the distance.
Okay, people won't necessarily like this statement, but I would always assume it's going to go the distance.
I think that
assume the absolute worst all the time. And then if you're wrong, okay, so what? So you spend additional time getting ready, organizing, and that organization paid off, right? It sort of undercut the need to go all the way. But if it does go all the way, you're going to be very thankful that you did it right from the start.
Right.
From minute one.
Right. Because at the end of the day, imagine what we'll put it back into your hands here. How much easier is it for you and your team to get an organized timeline that's very clear cut? And here's the evidence, here's the timeline, here's how it all works together.
Yeah.
Versus you having to
piece it all together.
Yeah, you don't have to get the yarn out.
So, yeah, obviously, it's always preferred that the file is user friendly.
Yeah.
From a lawyer's perspective. But on the flip side of that, the real benefit I see is it just saves so much money for the client. I mean, good attorneys can go through 20 bankers boxes and put it all together, assemble it, and you will have a fantastic file.
Yeah.
But the flip side is you're paying for that time.
Yeah.
And if you can sort of organize, you can keep that log, you can keep organized. I mean, you might save 80% right off the bat from what you're paying for a lawyer.
Yeah.
And so, that in and of itself is sort of the empowerment, because at the end of the day, if you do hire a lawyer, you want the biggest bang for your buck.
Yeah.
And if you can cut down on some of the stuff that the lawyer has to do, and what you have to realize too is when a lawyer gets a banker box of information, I would argue they have a fiduciary, because lawyers are also a fiduciary, to go through every single page. Why? Because if they go through, let's say there's 1,000 pages and they go through every page but one, but that one page happens to be the key, slam dunk smoking gun.
That's true.
They just breached their fiduciary. They weren't thorough. They fell below the standard of care. They had access to a document which would have turned the case, but they didn't review it. So you also have to remember they have these obligations to be thorough for your benefit, of course.
Yeah.
But sometimes you can actually spearhead that, organize it, send it over to the attorney so they don't have to spend 80 hours going through 20 banker boxes.
Yeah, that's a really interesting consideration, actually. Okay, let's go to I. Invest in knowledge. Read your CC&Rs. Find the maintenance responsibility section. Identify what the association is contractually obligated to maintain. Check your reserve study if the association has reserves earmarked for a particular repair. That's pretty powerful evidence that they knew it was needed.
Yeah, listen, invest in knowledge also always sounds like you got to do some homework. But unfortunately, if you want to be empowered, you got to do some homework.
Yeah.
You got to put in the work.
Yeah.
And I'm not saying read your CC&Rs from top to bottom, but be familiar with them. Go through them. Go through the index. Understand sort of what the table of contents says. I mean, really spend a little bit of time with them. Highlight, put Post-it notes. You should be familiar. And by the way, if you can actually identify some ambiguities, more power to you.
Yeah.
Because now you have an angle to sort of press on the board as well.
Yeah.
Force them to make a position on something, right?
Yep.
So I think the I invest in knowledge is also mission critical to enforcing your rights.
And I mean, don't sleep on if just because it's not in the CC&Rs does not mean they're not responsible for it.
Right.
It also, going back to what you said earlier, the Davis-Stirling Act usually has the fallback.
Well, there's your safety net.
Yeah.
Right.
So if you can't find it in your CC&Rs, you might be able to just start doing a little bit of searching and find it within the Davis-Stirling Act. We called out several things: the maintenance duties, reserve studies, enforcement, and attorney's fees, IDR. It's all in the Davis-Stirling.
And it's all online nowadays. You don't have to go to a law library, right? So it should be fairly accessible to you.
Yeah. Yep. Okay. K, keep it precise. Don't say you're letting my house fall apart and you don't care. Say, per CC&R section 7.2, the association is responsible for maintenance of specific element. I provided written notice on this date. As of today, no repairs have been initiated. This may be a constituted breach of the governing documents and a violation of the board's fiduciary duty under civil code, blank, blank, blank.
Yeah. So keep it precise, kind of going with this notion of make things turnkey, make it easily accessible. When you say you're letting my house fall apart, if someone's reading that, they're like, well, what part of your house? Why? What are you talking about? Okay, it's falling apart. In what sense? Right? And your anger and your emotion is like, my whole life is horrible because of you. But if you can actually walk someone through the problem, say, hey, specifically there's a leak in my master bedroom and it's causing damage to my floor. I think it's coming from a common area. I checked the CC&Rs. You guys are responsible for the common area. I had a expert come out and I'm attaching a report that says the water is definitely coming from a common area pipe.
Yep.
All of a sudden, that email is so much more powerful.
Yeah.
Because at the end of the day, if you're going to continue to enforce your rights, you're going to have to, at some point, prove up and articulate that anyway.
Oh, for sure.
So might as well have your opening move be one that's very clear that anyone, including the board attorney, who will likely see that email, will say, okay, let me actually run through this to see how much of a threat this actually is.
But also, I think the other thing that it does, it reveals the difference between someone that can be ghosted and someone they should take seriously.
Yeah. It does telegraph that this is, to use our vocabulary, it's an empowered homeowner.
Yeah.
This is not just an angry person.
Yeah.
This is someone who's empowered, who understands how these things work. And we're going to put a threat level much higher.
Sure.
And when the threat level goes higher, action typically happens.
Yeah. And that might just be them contacting their own lawyer, which might just get the adult in the room. In some cases, that might resolve it.
Correct.
The adult gets in the room and everything, it gets problem solved.
That's your best case scenario. But sometimes, and we'll get to this, that adult in the room, the attorney, is just a sort of weaponized arm of the association.
Sure.
And we've seen that before. And what I mean by that is, an attorney who is just at the beck and call of an association and is sort of used to weaponize or has been used as a weapon against homeowners.
We've always said, if the association is bringing their attorney, probably a good idea to bring your own. I mean, especially, you don't want to get into some legal mental jujitsu. You know what I mean?
It gets dangerous quickly.
Yes.
And all of a sudden you're getting flooded with documents to sign, or they're trying maybe to put you in a position to at least admit something that isn't true.
Yeah.
So you have to be so careful when interacting with a lawyer, unfortunately.
Yeah.
And so you don't want to fall into a trap where, you are engaging with a lawyer. The lawyer is sort of building a file against you, unbeknownst to you.
Yeah.
And all of a sudden you go to the lawyer, your own lawyer, after you've spent 6 months negotiating with this other attorney.
Yeah. Yeah.
Damage may have already been done.
Okay. E, last and strike, escalate only if necessary. We've talked about this before. IDR is really a really great tool here in California, and you can speak to that briefly if you would like.
Yeah, so IDR comes up where often I would argue if there's some sort of information gap, IDR becomes a powerful tool. It's under Davis-Stirling. It stands for Informal Dispute Resolution. And what it is the homeowner reaching out to the board saying, hey, I want to have a meeting informally to discuss this really bad dispute.
Yeah.
Right? And the spirit of it is, the board sits down with you, typically without lawyers.
Yeah.
And you guys can be reasonable humans and work something out.
Yeah.
Now, I say that it's information or there's an information gap because IDR can often solve that. It's very effective. But when you have a tyrant on the board or a meddler or all these different personality types we've spoken about historically, IDR might just be a complete waste of time. If you're dealing with a tyrant who's just going to yell and scream at you, maybe skip IDR and not get, berated.
Yeah.
It might not just be worth your time. Why subject yourself to that if you don't have to?
This also goes back to the concept of always be the reasonable one, right? At the end of the day, escalate only if necessary means your first move isn't just like, I'm calling my lawyer.
Right.
It's, I'm trying to be reasonable, work things out, be friendly about it. You know what I mean? Like, we're trying here to be the reasonable one. And that just bodes well for you later down the road, that you've always positioned yourself, everything that a judge potentially looks at, and like, this homeowner has been extremely reasonable all the way through.
Yeah. One thing too is, if you do find yourself in IDR thinking that you're just transferring information and all of a sudden the tyrant or this individual shows their fangs and starts spitting venom all over you, don't respond. Just terminate.
Yeah.
Because, your inclination is going to be to yell back.
Yeah.
But now, quite possibly, you have maybe 4 or 5 board members who are going to reinterpret that story where you were the crazy one yelling at them.
Right.
Which could be a trap. I think there's a new term. It's called rage baiting. I don't know if you've heard this term, but you try to bait someone into raging.
Yeah.
Right. Or going into hysterics.
Yep.
And so I've seen IDRs turn into that. That becomes a trap unto itself. So point is, keep a high guard. If they attempt to rage bait you or they just are berating you, just call it. Just say, hey, you know what? This is not effective.
Not going anywhere.
Yeah. We're going to take a different route.
Yeah.
And just terminate.
Yeah. Okay. To wrap up this episode, let's talk about when to lawyer up. Maybe a couple cases of maybe it's time to seek a legal professional. When there's active property damage, right? Water intrusion, mold, structural issues that are getting worse, your property is being damaged in real time. Don't wait.
Yeah, I would say, if it's ongoing, the board knows and nothing is happening, or they're dragging their feet, or there's excuse after excuse, it might be time to talk to a lawyer, or at least consult with a lawyer.
Yeah. The board denies responsibility despite clear CC&R language. They're telling you it's your problem when the documents clearly say otherwise. They are misrepresenting the governing documents.
Which happens all the time. They'll say, hey, we have no obligations under the CC&Rs, therefore this is your issue, when it clearly says something different.
Yeah.
Okay, you don't have to tolerate that.
Yeah.
But at that time, you might want to get an advocate to really start enforcing those rights.
They have notice and refuse to act. You've put them on written notice, followed up multiple times. Nothing happens. Inaction after notice is strong evidence of negligence and breach of fiduciary.
Yep. Time to put fire on their feet.
Yeah. Health and safety risk, mold exposure, electrical hazards from water intrusion, structural instability. This crosses from property dispute into a health and safety issue.
Yeah. Now on 4, you're typically moved out of the property. Right. At that point, if there's real risk to health and safety, just get out, find a location, and then sort of deal with it at that point.
They're sitting on reserves. This is interesting. The reserve study identifies the repair. The money is there. The board still won't act. That's potentially willful breach of fiduciary duty.
Well, that's a huge red flag. That'd be problematic.
Yeah.
So again, there you may want a more aggressive approach.
And we already mentioned this before. You get the HOA's attorney's letter. Same as always. If they lawyer up, you should, at minimum, consult with one.
Yep, I agree.
And then finally, the special assessment instead of using reserves. Board defers maintenance, then lets things deteriorate, then passes the cost to homeowners through a special assessment. Could be challengeable, might be worth having someone look at it.
Special assessments, those become somewhat nuanced.
Yes.
And I think it's worth maybe at least an hour time for a lawyer to actually examine under a microscope. See if this is legit or illegitimate.
Yeah, because, going back to it, there are times where a special assessment is absolutely warranted.
100%. But it's procedurally driven. There's a lot of red tape around them.
Yes.
And so if that's the case, maybe have a lawyer to make sure that the association has checked all the boxes, or there's nothing fishy going on with the special assessment.
Yeah.
Okay.
I think that's a wrap of another episode.
All right. Well, very exciting. We would love to hear your thoughts on this episode. Again, go to our Reddit on Bad HOA. And we just want to thank you guys for supporting the show. Again, we'll be dropping more merch, and we're going to keep fighting for the homeowner.
Indeed.
All right. Thank you guys.